Right, variation of contract. This is where your boss has given you notice he's changing your contract. He's taking away, perhaps reducing your pay, or taking away some other benefit, or reducing your hours in a way that's against the contract that you've always had. And you may have looked across the internet looking for advice from the ACAS website, or other solicitors and things like this, solicitors websites, and you might see that there's a sort of a consensus that an acceptance that there's sort of good faith between workers and management, but you and I, because you're here, you and I know that sometimes it is disastrous to lose those benefits that workers have fought for many a decade to hold on to, and sometimes we don't feel that there is that sort of level of when they come around and say we're going to take this or that away from us, we don't feel that level of trust that ACAS said we should rely on it being there. Well, this video is for you as a social activist, or a beginning shop steward in a union. First, obviously, the first port of call, if you've got one, is go to your shop steward. If that's not possible, and you are some sort of social activist, and you're looking at trying to build up a union, and this sort of disaster has taken place where management have made this sort of decision, and it's created a huge drop in morale in the workforce around you. You may think to yourself, well, here I can show here is the proof of what I've been saying. Now all I've got to do now is think, what can I do to try and stop this, or to try and negotiate a way out of it. So this is for you. This won't be much use to an experienced trade unionist, but there's not a lot out there for the beginner, which is why I've done this. So with a variation of contract, the first thing you've got to understand is that a contract is binding on both parties. It cannot be changed until both sides have agreed. Now that's the first rule. Once you've got that out of the way, now most people know that instinctively. So you might ask, Tom, so what are they playing out then? How are they getting away with this? Well, what they can do is start negotiating to change the contract. So they can say to you, they can send you a letter saying, I need a meeting with you Monday morning. We're going to talk about reducing your pay by £1 an hour or whatever, because the company is suffering, and we're not in tip-top condition as an economy, but we as a social activist, and that includes me as an experienced trade unionist, and the sort of social activist that doesn't have a union recognition agreement. What we both agree on is that why should the workers suffer? Because the bosses certainly aren't going to be. They're not going to suffer the disastrous loss in living standards and other benefits. So it's our struggle to push back against this. Now, we know that the contract is binding on both sides. So what they're aiming to do is to change the contract. So they'll say to you, well, we want to reduce your hours, and we're doing it to try and save the company. So what they're trying to do is to establish that there is a substantial reason why they've got to do this, because they're going to be thinking about justifying it in court later on if it goes horrifically wrong for them. So they'll establish a substantial reason for doing this, and then go to you and say, look, we want your agreement. And it's at this point all hell breaks loose. Everybody starts swearing. Every staff meeting is horrible. and then a sort of a malaise will go around where people say, well, oh, this happens all the time, it only takes 45 days, they consult with us for 45 days and then it's all over and then we lose. Well, what I'm saying to you is it doesn't have to be that way. There is a tactic that they can use is where they say, well, if you don't agree to it, what we're going to do is dismiss you and re-engage you on a new contract, which they can do. They've got the right to dismiss you with notice if there's a good reason for it, and they'll say there is. This is what making a substantial reason for doing it. And incidentally, if you're an aficionado of the Employment Rights Act, you'll see there's a mode of dismissal called some other substantial reason. So this means you can be dismissed for other things than just being naughty or too sick to work or whatever. You can be dismissed for some other substantial reason, and what they're trying to do is, so with this sort of dismissal, they'll try and use that technique to say, well, the company needs to change, otherwise we're going to go under, and that's the substantial reason. So so what you do, you can try and demolish this substantial reason. Well, how come you've just bought a new Jag? Things like this. Can we see the spreadsheets? Can we see what the incomings and the outgoings are for the company? All this sort of stuff. So you can start going down that route as a beginning shop steward. That's a good tactic to go with. Let's see the figures. Are you really going under? But anyway, yeah. So what they can do is dismissal and re-engagement. So you will be. They'll say, we will dismiss you with X amount of notice, whatever it says in your contract. The amount of notice is required, and re-engage you on new terms and conditions. Now, what nobody knows, what very few people know, is that you can accept that, after all the rowing, you can accept that new contract at the end of it and still take them to the tribunal for unfair dismissal. You can say, I've been unfairly dismissed and this is the reason why. You can go for this substantial reason business. You can go, no, it's total nonsense. But it's difficult to, it can be difficult to prove because all management do is got to substantiate in some form at a tribunal that they are under difficulties, and a judge will tend to accept it. But what it poses, this ability to do this, it poses to the opposition the fact that if they do this to, say, 20 people in a workforce, they might end up with 20 tribunals, in which case they're going to be answering to the shareholders and bad publicity, and maybe they're a trust with trustees are going to jump up and down. Maybe they'll end up in papers and things like this. So what you can do is you can go for the unfair dismissal sort of line, but that's the end of the process. But in between, there's an awful lot of negotiating. The HR bod that will come along with your manager when he's doing all this will know all this. So you as a social activist can say, look, we think this is unfair. I think it's, yes, we might have to accept this new contract, but at the end of it, we're going to take a tribunal claim. If it's over money, you can just say you can in a slightly different. Yeah, sorry, the battery ran out again on my camera. Yeah, we were talking about variation of contract. We got up to money. Now, so he wants to your employer wants to change your pay, to reduce your pay. Now, let's look at the scenario. He's consulted with you. He's told you it's going to happen. He hasn't listened to you when you told him the sort of disastrous effect it's going to have on your life, and everybody else's. And remember, consultation, we've done this in a previous video. Consultation is a two-way street. It's a exchange of views. So That's its definitions, where he's got to consider what the other side have told him while making his decision. Doesn't mean he has to do it, but he's got to consider it. So he hasn't listened, and he's gone ahead, and he said on the 1st of March, you will be paid £1 an hour less. So what happens then? 1st of March comes along. You're not happy. There's a couple of things you can do. One of which is you can, when you get paid on the 31st of March and it's less than you had on the 28th of February, it becomes you can then take a claim for unlawful deduction of earnings, a deduction of wages. I can't remember the exact term, but you can look it up, Google it. You don't have to leave your job to do it. You just carry on. Now your boss won't be expecting that. Hopefully he would have taken legal advice before doing it, but he might not have done. So that's one thing that you can do. That's an option. You also that isn't with dismissal and re-engagement. That's if he's just said, look, on the 1st of March, because it's in his power to turn around and say, I'm not, because he signs a check, so he doesn't, so he thinks, oh, this is easy, I'll just not, I've told him, I've given him consultation, and I'll just pay him less. So this is when you go for unlawful deduction of wages. Now, another thing you've got to do, if you're thinking tactically to try and win, you should be bunging in a grievance, because he'll send you a letter saying, from the 1st of March you're not getting any, you're getting less money. You've got to put in a grievance, because at a later date, a judge will ask you, well, why didn't you do everything that you could have done to make things right? So put in a grievance. If you don't, and you don't put in a claim, you might think to yourself, well, I haven't agreed to change to my contract. You just told me contract hasn't changed. Well, you'd be wrong. What you've actually done, if you don't put in a grievance, and you've got to do it quickly, you've done what is called affirmation. You've affirmed by working to his new contract. You are now, it's as if you said yes, okay, that's fine. So you've got to be quick. The longer you take, the less likely it is you will win at a later date, legally, through the legal route. So a week might be too long. So you've got to bung in a grievance, write him a letter saying, I disagree, I would like to go through the grievance policy. Usually in my firm, you've got to go through an intermediate stage, one that's not so serious, where you've got to try and sit down with and try and sort it out before going through the formal procedure, an informal procedure. So, but start it, and then say you're not happy with it, and proceed from there. If you don't, you've affirmed the new contract. So what then? Say it's not about money. Say it's about something else. You've lost a day's holiday, something like that. Now you can't do unlawful deduction of wages because it's got nothing to do with that. With holiday, it's a change of contract, and you don't agree with it. What do you do then? If it's you do exactly the same, when the time comes, the change it immediately, as quickly as you can, get a grievance in. You must try and settle with him, try and settle some sort of agreement. If it doesn't work out, then the final resort you have, and we haven't even talked about industrial action yet, and things like this, but this is the pure legal, as if you're just two people in the marketplace negotiating. What you have is constructive dismissal. This means
what you're saying is your employer has made it so awful. Your circumstances of working there have been so awful. He has, by you leaving, what has actually happened is he's dismissed you. That's what constructive dismissal means. It's even though you leave, his behaviour towards you has made it impossible for you to stay. So it's like a type of bullying, and you had to get away, and you bung in a constructive dismissal claim. Now the problem with constructive dismissal claims is they're quite hard to win, but and also with this sort of contract change, you will have to prove to a judge that it's of a substantial reason. So we've had cases where people have lost, like 20 pence a mile off their expenses, their petrol allowance, and have taken constructive dismissal and have taken a constructive dismissal case and have lost because the judge has turned around and said it's not substantial enough. It's not serious enough. You should have lived with it, and we know it's unfair. But what the court is trying to do is trying to balance the rights of the workers. I know it doesn't feel like it. It's trying to balance the rights of the workers with the right of the employer. And the judge would really want you to try and sort this out. So he doesn't like it if you leave, even with a constructive dismissal case. But he can understand it, and he will accept it if it's serious. It's a serious problem. Like £1 an hour is a serious problem, and you've tried to you put in a grievance or something like that. You've tried to sort it out yourself, and it hasn't worked. But anyway, I'm going to do a flow chart. I'll put it on the website to show you what sort of these are just the legal tactics. There's other stuff. If you're a beginning trade unionist, then go to your branch and say we're not happy with the change of contracts. Can we have a ballot to decide whether or not we want to take industrial action? And we can still do that. It's law enshrined in British law and in European law and international law. You still have the right to do it. But if you're a social activist in a small firm, you're without union recognition, your means of taking action are quite limited. My union has a policy of no unofficial industrial action because it doesn't want to be liable vicariously. I have to tell you, you might think, Tom, you're a bit of a traitor. No, what I'm trying to give you the facts. If you are considering an official industrial action, bear in mind you can be dismissed with no recourse to, because a tribunal won't accept. If you take an unofficial industrial action, your dismissal is fair as far as the law is concerned. So and basically solidarity is your only comeback. But in this day and age, it's quite hard. But it has happened. But obviously, my union won't endorse anything. I can't endorse anything like that. But but anyway, this is mostly about the legal side of variation of contract. So I'm going to do a flow chart. I'm going to put it on the website. Have a look at it, and I'll show you what sort of options you've got, the legal options. And I hope this is a good starter for you to give you ideas to sort of start things. Trying to make things fairer in your workplace when you're under attack. So that's it for now. Thanks, brothers and sisters. I shall speak to you soon.